This is Kent Moreland. I am the editor and publisher of morelaw.com, an internet-based legal newspaper, and I'm here today talking to Tulsa employment lawyer Jeff Nix about the Family Medical Leave Act. What is the Family Medical Leave Act, Jeff?
Well, the Family Medical Leave Act is the newest of the various civil rights statutes. Since '64, we've had race, color, religion, sex, national origin, age, disability, and that sort of thing. Family Medical Leave Act was devised as a way to allow people in the workplace that work for larger employers, 75 or more, and people who are relatively long-term, have to have worked for more than a year. That allows them to have time off, unpaid time off, for up to 12 weeks for a serious health condition of theirs or for a serious health condition of a family member.
Mother, father, child, that sort of thing.
Exactly, and that's defined in the statute. So you have to have been there for a year. They have to have 75 or more employees, and you can take up to 12 weeks of unpaid leave. Unpaid leave. I'll come back to that in just a second. But you're entitled to 12 weeks every rolling calendar year. So if you use your 12 weeks between June and June of 2011 and 2012, on June 12 of 2012, you're getting another 12 weeks. And it's unpaid leave, and it will run at the same time as paid leave. So an employer has to give you the 12 weeks, but if you've got vacation coming, then the employer can make you use up your vacation time.
Can you use sick leave?
Exactly, same with sick leave. So the disadvantage is you're using up that leave, but the advantage is, since FMLA is unpaid, at least you're going to have some money coming in.
And what if your employer, after you've had your 12 weeks off to take care of your child, your mother, your wife, whoever, what if you don't get to go back to work? What if they won't take you back? Is that the relief, basically, that you would recommend?
You know, the reason, and that's question number one. You've done your 12 weeks, and you're still, and now you're ready to come back to work. The reason they picked on larger employers, 75 or more, they're saying, look, if you've got that many employees, you should be able to cover for a person that's got to be out because of their own illness or because of an illness of a family member. So when they when they try to come back to work, you've got to find a spot for them.
And if they don't, is that when they call you?
That's a wrongful termination.
Now, do you have a website that talks about this at all?
I do. It is tulsaemploymentlawyer.com, and there's a great deal of information on there about the Family Medical Leave Act. There are the forms that you file with the EEOC, and there's information on how to contact me, telephone, fax, and email.
Right. And let's say that they go there and they think that the Family Medical Leave Act has been violated by their employer, and they call you. What kind of questions are you going to ask them to decide whether you're interested in representing them?
Well, of course, the first question is, do you qualify? Have you been there a year, and do they have more than 75 employees? So if either of those is absent, then I'm sorry, but you're out of luck.
I've seen some cases where they seem to quibble about whether the employee has given the employer adequate notice that they want to take this. I mean, what should someone who's wanting to take Family Medical Leave Act time off to take care of a wife or whatever, what should they do? Should they go to the employment office, personnel office? How should they communicate their desire to take this leave?
Well, of course, number one, employers 75 or more need to post notices that they're covered by the Family Medical Leave Act. The employee's responsibility is simply to go to the employer and say, I have this serious condition for myself, or I have this serious condition for a family member, I need to be off work. At that point, the employer is supposed to step forward and provide the forms because there's a request for medical information, etc. So once you notify the employer, it becomes a responsibility of the employer to make sure all the paperwork is done.
Would you prefer though that, well, of course, you're not seeing these people generally before they have a problem with their employer, you're seeing them afterward, correct?
Well, of course, I'll see them when they're denied family medical leave. The employer says, yeah, we're covered, we're not going to give it to you.
So there's really two sides of, they won't let them take off, force them to resign or do whatever, or they let them take off and then they won't take them back. Is that the two most common situations that occur?
And these are both wrongful terminations. If you got to go and they won't let you go, and therefore you are deemed to have quit in their eyes, well then that's a wrongful termination. If it won't put you back, it's a wrongful termination. Now, family medical leave, the entitlement to family medical leave begins after 3 days of absence. So if you are absent because of a serious health condition, then on the 4th day, you are now covered automatically. You're now covered by the Family Medical Leave Act, and you can't be terminated. Well, even though there's been no paperwork whatsoever, so long as you have notified them, you know, I'm sick, I'm not coming in, or I'm having surgery, or I had a car wreck or something, or
my wife's had a heart attack, or my husband's had a heart attack. Need to call your employer and say, I got this problem, just want to let you know.
And it begins on the 3rd day, and an amazing number of employers will have something in their policy that says if you are a no-call, no-show for 3 days, you're deemed to have quit. Now, I got news for you. The way to quit is to say, I quit. If you are a no-call, no-show and they say you don't work here anymore, that's a termination. So on the 4th day that you are off work because of this family medical condition, then you are protected, and if your employment is terminated, then that's a wrongful discharge.
Okay, well, let's say somebody has been subject to a violation of the Family Medical Leave Act, and they call you up and they tell you their story, and you decide to represent them. They need to bring their checkbook to pay you for your time, or is it a contingency fee case?
No. Some employment lawyers do that. And I just think they ought to be ashamed of themselves, because the person's, I mean, what part of I got fired and I don't have any income do they have difficulty understanding? And the way I practice, and I've just been doing this more than half my life, and I tell people, I know you're upset, but your lawsuit is a business deal, and I'm going to be your partner, and I'm in for a third.
That's your standard fee?
Yes.
Plus your expenses, I assume, right?
Right. And there are not really that many expenses in these things. I've learned how to do them, pretty quickly and pretty cheaply. Now, with the Family Medical Leave Act, if you're successful, if you go to court and win, then the successful attorney can be awarded an attorney's fee, which I then back out of the 1/3 that I've got. So I tell people, they'll say, well, do you believe I have a case? And I say, well, look, I'm in for a third. Third of nothing's still nothing. Right. So if I didn't believe in it, I wouldn't be your partner.
So let's assume that you ended up with $100,000, just to make the math easy here. Mm-hmm. You would be entitled to $33,333 of that, less if the court orders them to pay you $20,000, then you only get $13,333 from your client. The employer's paid $20,000, so your client would end up with $86,666.
Yeah, I'm dubious of your math, and I couldn't do it in my head. But,
well, it is correct. I'll tell you that.
Okay.
I can do it in my head.
All right, I'll take your word for it.
Is there anything else that you would like to tell people who might see this video about the Family Medical Leave Act that we haven't already addressed?
Well, here's what I say. If you have any thought that that the Family Medical Leave Act has been violated, you need to contact the EEOC and file your claim. Doesn't cost anything, and you can get on my website, TulsaEmploymentLawyer.com. The form for filing with the EEOC is there. You have 180 days to file, so don't let the grass grow under your feet. The EEOC will do an investigation. It won't cost you anything, and at least you'll have peace of mind if they look at it, and so if EEOC looks into it and says we don't think there's a violation, then you say okay. At least that answers that question.
Let's say that the EEOC says we don't think there's a violation, or let's say they think there is. Well, first off, they say we don't think there's a violation. Does that mean it's over with?
No, it does not. No, it does not. And all of these, if you're going to go to court, you're going to go to the United States District Court for the Northern District of Oklahoma if you're around here, or whatever federal court in your jurisdiction. And here's how much district judges pay attention to what the EEOC says.
Really?
None whatsoever.
Now,
whichever way the EEOC, if the EEOC says, oh man, that's a violation, federal judge says, this is day one. We start right now.
Well, what generally happens is the employers, if the EEOC says there was a violation, do the employers often then try to settle with the employee right then? Or do you find that they remain intransigent and they're not cooperative?
Well, the EEOC, in times past, I would say, would have to save up to be worthless. In the last 2 years, the EEOC in Oklahoma is now being headed by a very aggressive former plaintiff's lawyer, Jeff Lee. And so now the EEOC does first-class investigations. But they don't investigate every case thoroughly. They do what they can with what they have. So I tell people, don't worry about what the EEOC says. Listen to what I say.
All right. Now let's see. Maybe there's something else we need to talk about here. Oh, let's say that they get a right to sue letter. How much time do they have to hire you or someone like you to assert their rights in the federal court?
Well, of course, there's nobody like me. But anyway, they have 90 days. And I mean 90 days, not 90.11111 days. It is 90 days from the date of receipt of the 90-day right to sue.
It's not the date on the letter. It's 90 days from when you get it in the mail.
That's correct. But they assume or presume a normal, somewhere is 3-day delivery, some days 5-day delivery. But let's say you've got proof that you didn't actually get it until a certain date, then you go 90 days from that.
Better off to go from 90 days from the date of the letter itself, though.
Yeah,
Right?
and I mean, I have literally had people come in on the 89th day, and I've had to crank out a complaint and file it. And I can do it, but my nerves are shot for days.
Well, once again, what's the name of your website, Jeff?
TulsaEmploymentLawyer.com.
All right, and what is your telephone number if they just want to pick up the phone and give you a call here?
918-587-3193 for a good time call.
Thank you for taking the time to talk to us. I think people will learn something from this video. You have a good day. Goodbye.